everybody, and welcome back to my channel, or if you're new here, hi, hello, welcome. I'm Spooky, and today we're finally talking about the TikTok defamation case. Now, some quick housekeeping rules before we jump into everything else. Very quickly, if you want to jump around, there will be chapters down below. Just go into the description, click whatever one you want, there's the chapter. 2, we are going to be respectful. This has been a chaotic case. I think in one of the court filings, it was like a clout circus. It definitely was chaotic and crazy, but we're gonna be nice and we're going to use our nice words. So please do that. I will not be talking, or I will not be calling the TikToker by their name. They will just go by TikToker or TikTok Psychic. If you don't know how this case started, it started off with a really sad tragedy. Very gruesome murder. So we will give some context of what actually happened with the murders, and then we will jump into what actually happens 10 days after the murders. Now, it's going to be a weird switch, so bear with me as we talk about the murders and just the awful thing that happened, and then we jump into the chaos that is the TikTok defamation case. With all that being said, grab a coffee, grab a blanket, and let's dive on in to this entire TikTok defamation trial. On November 13th of 2022, 4 students of the University of Idaho were murdered in an off-campus home in Moscow, Idaho. The victims were Kaylee Goncalves, Madison Mogan, Ethan Chaplin, and Zaina Kernodle. These murders were a shock and a tragedy throughout that entire community. In December of 2022, the murderer was arrested and later convicted in 2025 and is now serving 4 consecutive life sentences along with 10 years for burglary. This is a tragic case, and I do not want to undermine it by talking about this whole defamation case, but this is the reason it started, and I didn't want to skip over this because I think it's very important to talk about the victims and what happened to them. Because unfortunately, due to this trial, I believe that this case was kind of undermined and a lot of its resources were used to almost disprove this entire defamation case before the murder hadn't even been found yet. But with all that being said, this tragedy is what it is. There are still litigations going on in that specific case in itself. So we're not going to touch on it much longer, but we are going to get into what happened shortly after and what turned into the TikTok defamation case. I just wanted to take a moment to honor the victims, say their names, and make sure that we do not forget them, but also show how something so awful can turn into something even worse because of one person's opinions who probably should have kept them offline. On November 23rd of 2022, a TikTok user reached out to the TikTok Psychic and asked if they could do a tarot reading on these murders. The TikTok Psychic decided to do one. They started to do one shortly after on November 24th. Now, on the 23rd, according to the TikToker, she could tell through the tarot cards that it was a possible professor or student that had committed the murders. Later, on November 24th of 2022, she would come on to TikTok and make a video claiming that this specific professor up in Moscow, Idaho, was the killer. She not only used the professor's full name, but also the address of where she worked and the phone number, completely doxing her and having no proof besides tarot cards and intuition. Shortly after that specific video, a slew more would come out, and she would also be sent 2 cease and desist. One on November 28th of 2022, the second one on December 8th of 2022. This TikToker, not fully taking the hint, decided between the first one she made about this specific professor in November of 24, all the way up to, I believe, about December 8th, if not when the lawsuit was filed on December 21st. She made 114 videos either using the professor's full name in the hashtags or specifically talking about that professor in multiple parts. The TikToks, even though they were short, there were a ton, and it's just absolutely wild if you've actually seen the videos. I've only seen a few that were presented at trial, and I can't imagine going through that. The lawsuit was actually filed on December 21st of 2022 in the Idaho court system, and a service notice was sent out, and the TikToker was served with that lawsuit on December 27th of 2022. So a lot of information in a very short amount of time, but we're gonna go over 23, 24, and 25 kind of quickly. And then we're going to go into the main bulk, which is from the beginning of February until the end of February when the trial started and finally ended on February 27th of 2026. Fair warning, it's a lot of content. So I will throw up documents as I go. That is kind of important. And then if I don't feel like they are important, then they won't be shown, but I will have most of the court documents available. So I have my notes on the side of the screen. So if you see me looking over, it's just to make sure that I'm chunking out everything properly to make sure that we cover the majority or the main points that I really want to cover. So on January 19th of 2023, the declaration or the motion, apologies, for entry of default judgment. This was mainly to just state that the TikToker did not respond within the 21 days of service, and that they should enter a motion of default and move forward. Then later on January 27th, the clerk did an entry of default as to the TikToker. And pretty much just, again, what these mean is that, hey, we served her with the lawsuit to pretty much tell her, like, hey, we're suing you. Please do X, Y, and Z and respond, or we will move forward. She did not respond. In early February, she finally did formally respond to the lawsuit and file a counterclaim. While what she argued was that she denied that the defamation allegations were true. She claimed her statements were opinions or beliefs due to her tarot cards and intuition. And then she also filed a counterclaim against the professor and the professor's attorney. Mainly, she was just trying to turn everything back around onto them. A couple days later, the professor's attorneys then filed a motion to dismiss the counterclaims, pretty much stating that the counterclaims or trying to sue the lawyers were legally unsupported. The attorneys have immunity for litigation actions, and that the TikToker's claims against them were just improper. They also filed a motion to quash the summons, which was pretty much to say, like, hey, we cannot be sued simply for representing a client, and the summons against them is technically invalid. The motion to quash and everything like that is pretty much just to say, like, we're doing our job. You can't countersue us because we're doing our job. Later on August 8th of 2023, the judge then issued an order addressing the multiple motions. So the counterclaims was dismissed. So the TikToker could not move forward with her counterclaims, and the attorneys were removed from the case. So the court did quash that summons against the professor's lawyers. On October 10th of 2023, the professor's lawyers filed a motion for partial summary judgment. Pretty much what this was meaning was that they were asking the courts to find the TikToker liable for slander and defamation. They submitted a full document for the partial summary judgment. They also filed a memorandum in support of the professor's motion, as well as statements of undisputed material facts, and then a declaration from the actual lawyer in search of the motion of partial judgment, a bunch of exhibits to attach to that declaration, as well as the declaration of the professor in support of that motion. Then on October 31st, there was a response to that motion filed by the TikToker. Her argument was pretty much just saying the statements were based on an intuition. They are not factual claims, and that the professor has not proven defamation. On November 13th, the judge then ordered that the motion to set aside or motion to dismiss was denied, and pretty much stating that there is a possibility, but liability has not been found yet, and they can move forward. On to 2024. There was a lot more. There were a few in-court meetings that were held over Zoom and stuff of that nature, but mainly that was the gist of 2023. So in 2024, on January 12th of 2024, the professor filed a motion or amended motion for partial summary judgment. Pretty much just saying, hey, we kind of screwed up a little bit. we want to amend this and submit a whole new motion for partial judgment, as well as some of the facts that we didn't have in at the time that we want to add in. Mind you, this specific document in itself, right? It does have the main motion, but it also has 26 attachments. And out of those 26 attachments, 3 of those are not actual exhibits. So there are 23 exhibits in support of this motion for partial summary judgment, which is just insane. And a lot of them are TikTok videos, medical records, possible security receipts, and a few other things. And we will go to those once we hit court. But this was a stacked document to turn over. They also later on that day re-entered another file for a motion for leave to file amended complaint to add punitive damages, and that's mainly where that amended motion came in. Later on, February 2nd, TikToker then filed a response to the amended motion, and it was mainly just her formal opposition along with her exhibits to that particular motion. She filed a response, and then she filed 8 different attachments, which I did not include one of them, and I will tell you why right now. You cannot go on to a victim's Instagram and scroll through and take pictures of all of their Instagram stuff for no reason. There are about 30 pages of this, mind you, of Instagram pictures and something of one of the victims that supposedly, according to the TikToker, the professor had an illegal relationship with. Now, I'm going to get into what the actual videos and everything said at trial, because it does come out, but it's just awfully distasteful to throw that in. At the time that I looked, I didn't know what it was. I really wish I didn't click on it, to be very honest. On February 16th, Professor then filed a reply to the response, and it was just a final briefing before the judge did consider the motion for partial judgment. Later on April 16th of 2024, the oral argument hearing was held. They held a meeting on the amended summary judgment and as well as the punitive damages motions. And then the judge took the motions under advisement, which pretty much meant he heard all the arguments. He has taken notes on everything. Now he's going to go and he's going to sit on it and review all the possible things before he actually makes a judgment in one way or another. And shortly after that, on June 6th of 2024, the memorandum decision and order was issued. And the plaintiff's amended motion for partial judgment was granted on the issue of liability only. So what that means is that they found the TikToker liable for defamation and slander, but they cannot rule on damages, but they are allowing punitive damages in. So now the only thing they have to do is go through and decide on a jury trial and when that will be for damages. Really quickly, before we dive into 2025, there are a few things that in the beginning I didn't think were really significant, but they do come up later on. One of them is on June 13th, and it was a motion for reassignment to a U.S. district judge by the TikToker. And pretty much what this meant was that they felt that the damages didn't meet the threshold for federal court. So the threshold for federal court is $75,000. If you can prove that there's a possibility of damages from $75,000 and above, it will end up in federal court. But she was trying to say, nope, this should go to a U.S. district court. I don't believe that the damages are this much. She also then again signed another motion to amend or correct the order on motion for partial summary judgment on June 24th, pretty much just stating to the judge again that she believed that this did not meet the threshold for federal court and that it needs to be moved back down to a U.S. district court. And mainly for the rest of 2024, they're just going back and forth to have this battle on whether they should fully remove down to the U.S. District Court or not, and if it met the threshold. And finally, on August 19th of 2024, it was in a very judgely speak, it is hereby ordered that defendants' request for reassignment to a U.S. District Judge and to the extent necessary to address that request, defendant's motion to alter or amend judgment be referred to a United States District Judge for resolution as necessary. It is further hereby ordered that defendants' identical request for reassignment to a U.S. District Judge is denied as moot. Magistrate judge that was presiding over this said, fine, you want to move it down, that's perfectly fine. Let's take it down, throw it out in front of a U.S. District Judge, and they can have the final say. Well, lo and behold, on November 13th of 2024, the memorandum decision and order was filed. So the TikToker's motion for reassignment to a district judge is denied. And it was signed by a judge who did work on in the district courts. It's a interesting way to go about it, but it was denied, and then it was later moved back up to the magistrate judge that would later preside over the trial. We're now into 2025. So this is when most of the filings are supposed to be about discovery and everything in between about discovery. Some of them are, some of them are not. It's a little weird because the TikToker is constantly trying to say that, one, the threshold of damages aren't great enough for federal court, two, that the court has no jurisdiction over her, and three, you can tell in the motions and in her filings that she's really just trying to delay this trial. It was wild to watch, mainly because I found this out after all of the main liability. I found out after defamation had already been kind of thrown at her in 24. This is just insane to me, but you can tell in a lot of her court filings that she's either trying to delay or she's trying to get out of having to come out to Idaho, to Boise. One of her first motions in 2025 is filed by her. She files a motion to alter or amend the judgment, and she's pretty much asking the court to reverse or change the June 6, 2024 ruling that did find her liable for defamation. In the TikToker's argument, she's claiming that it contained errors of law or fact, violated her First Amendment rights, allowed excessive damages, and also showed judicial bias. She is again asking the court to dismiss the case entirely based on these specific arguments. The court did reject her motion later on and kept the defamation ruling intact. She also then filed another motion for reconsideration. The TikToker claimed that there were newly discovered evidence, and what she said was that the filings in the Idaho criminal case related to the murders supposedly supported her claims, and her position was essentially the new evidence proves her TikTok accusations that might have been true. The court pretty much said no. They said that the new evidence did not change the defamation ruling, and that the rule that she wanted relief under, which was Rule 60, did not meet that, and that rule of relief is extraordinary to do. So the motion was denied. On May 30th, the magistrate judge did issue an order denying TikToker's reconsideration request. The ruling found that the evidence she claimed that was new would not change the outcome, as well as the defamation ruling still stood. So this order is also what triggered the next few. So on June 12th of 2025, TikToker filed another objection asking a district judge to overturn the magistrate's ruling. Again, her argument was for the fact that evidence was being withheld by the state. The court improperly required her to prove the accusations false, and that there were due process issues that existed. The court district judge did reject her objections and leaving the magistrate ruling intact. On August 12th of 2025, with the liability and defamation issues now finished, the court then had a hearing to set the case for trial on damages. The key dates of this were that the trial would start on February 24th of 2026. The pretrial conference, there would be two. One would be on February 5th of 2026, and the final pretrial conference would be on February 23rd of 2026. Mostly these deadlines were for expert motions, witness lists, expert lists, jury instructions, and motions in limine. That is ultimately what the rest of 2025 was all about. There were a lot of motions to either exclude or include certain testimony, especially from the professor. The TikToker had a few, but it was mainly it was a lot of asking to exclude certain things that the lawyers felt were unnecessary, while also fighting their own from the TikToker. There were a few wins in the very beginning for the professor, i.e., a lot of the expert testimony that the TikToker was trying to exclude was denied, and also a protective order was placed on the plaintiff from the defendant, i.e., on the professor from the TikToker. So now we jump in to the beginning of February of 2026. This is a very heavy few weeks leading up to the actual trial itself. There are a lot of documents, and most of those which we will go through as we're talking about the specific trial. Just wanted to give you a quick little warning before we dive into it, because it is kind of, I'm not going to try to put in legal jargon because I don't even fully understand legal jargon, but it's just a lot. And we start on February 5th, and the actual trial itself ends on February 27th. So you're talking about, 22 days of possible filings, along with the pretrial conferences and a few others sprinkled in. So if you want to just skip to the trial, please do. For those who want to stay, let's dive in. So on February 5th of 2026, this was a filing by the TikToker, and it was for a motion to dismiss and lack of jurisdiction. So what she was arguing was to dismiss the entire lawsuit. She was claiming that the court had no jurisdiction to hear the case, that the professor did not prove damages over $75,000, which is required for that federal jurisdiction, that the professor allegedly fabricated damages and testimony with the two witnesses that they were fighting over, as well as damages supposedly were not legitimate and that the federal court should not have heard the case at all. Pretty much meaning that the court had no legal authority for any of this, which is kind of funny to do 22 days before, or not even 22 days. It was like, I think at this point it was 17 days, 18 days before. It's a very unusual time to submit this because liability has already been in place for over a year and some change now at this point. She also submitted a supporting memorandum. It was a 15-page memo explaining the motion. And again, the key points that she claimed were that the professor claimed damages were not made in good faith, that the professor supposedly did not suffer reputational or mental harm, that the witnesses allegedly fabricated evidence about PTSD and damages. Just wait until trial, I'll get into that. It's messy. And the amount in controversy was below the federal threshold of $75,000. Kind of some important context to also have in the back of your brain is the fact that the federal court determines jurisdiction based on the claim at the time that the lawsuit was filed, not what happens after the lawsuit is filed. In the beginning, when the lawsuit was first, placed, they said that there was damages over $75,000. And now that liability has been determined, it's a little hard to backpedal once it's already been set in motion. But she also attached about 13 different exhibits, and we'll go through some of those. So Exhibit A includes the professor's expert witnesses, two of which were Rebecca Talent and Rebecca Bond. Dr. Rebecca Talent is a journalist and also is a professor for journalism and public relations. And she also was going to testify that the reputational damage from accusations like these can last decades. And then the therapist. So this specific therapist diagnosed the professor with PTSD due to the online accusations. Exhibit D and E are the TikTokers and the professor's resume. And then F and G were the PTSD diagnostic criteria, which is the DSM-5, as well as the therapist license. I is a subpoena to Facebook and Instagram, pretty much just requesting records related to the case. And then J and K were stuff related to getting access to records for the Idaho 4 murders. Exhibit L was a request for public records from the university. And M was a snippet of one of her books that she self-published. They also later did have that pre-trial conference. Unfortunately, though, I cannot get into that minute entry text document. They do not have it on Pacer, so I could not grab it because I really wanted to see it. But it was probably just to go over a few of the motions proceeding, because she did file her motion for dismissal. And it even says here, following today's conference, the court hereby orders the following. Defendant shall file her motion for continuance on or before February 6th. The plaintiff shall respond to defendant's anticipated motion for continuance and defendant's 117 motion to dismiss by the 12th of February. And third, the defendant shall file any replies in support of defendant's motions for continuance and motion to dismiss by the 13th. That first motion that we are talking about is pretty much just, hey, reply to this, hey, make sure everything's good to go, and then we will move forward with either a grant or denial. On February 6th, a motion for continuance was then filed by the TikToker again, pretty much just asking the court for a trial delay. Her main motion, she said, would be unnecessary if her February 5th motion to dismiss is granted, or that the court allows an interlocutory appeal if the motion for dismissal is denied. The reason she mainly gave for the delay was that she wanted more time to prepare due to the testimony from the therapist and ongoing disputes about the expert testimony, mainly about those two that we talked about earlier, and the fact that she thought that they provided false or fabricated damages. And while she previously had filed a motion to exclude them, the court only partially denied that request, but allowing a chunk of the testimony to remain. She then also argued that the court still hadn't fully addressed her claim that the federal court lacked the subject matter jurisdiction, and this also then relates back to the claim that she made on February 5th. The interlocutory appeal, she does ask for time in this case that she wanted to pursue an interlocutory appeal if the motion to dismiss was denied, and it's mainly just an appeal before the trial finishes. On February 9th, the opposition to the TikToker's motion to dismiss was filed. So the professor's lawyers filed a memorandum opposing the TikToker's motion to dismiss for lack of subject jurisdiction. Their main argument was that the motion should be denied because the court has already rejected this argument twice before, as well as the fact that the professor's complaint clearly alleges damages over $75,000, which satisfies the federal jurisdiction. Again, federal courts only dismiss for this reason if it is legally certain that damages are below $75,000, which is a pretty high standard in court cases like this. The professor also states that the TikToker falsely accused her of ordering the murders of the 4 University of Idaho students and having a secret relationship with one of the victims. Professor claims that these accusations cause reputational harm, emotional distress, fear for her and her family's safety, as well as costs related to security measures. They were mainly just trying to say that the jurisdiction is based on the complaint, and if the damages were claimed in good faith, then the case needs to stay in federal court. That the TikToker is arguing damages and not jurisdiction. Her arguments are mainly focused around the PTSD or the reputational damage, and they are trial issues, but not issues to dismiss a case. And again, liability has already been decided. The court had already ruled that the TikToker statements were false and defamatory, and she cannot argue if they were true at trial. They also point out in their ruling that a jury can award punitive damages based on the conduct, but they don't have to. On February 11th, then they also dropped a motion to oppose the continuance of trial. The professor's lawyers responded to that February 6th request to delay. The main argument was that the court should deny the continuance and keep the February 24th trial date, mainly because this trial has been scheduled for 6 months and that the TikToker waited until about 18 days before the trial to ask for a delay. There is a major lack of preparation on the TikToker's part, and it is no fault of the lawyers alone. They did also argue that the TikToker did no discovery, did not file any pre-trial disclosures, did not prepare witness lists or exhibit lists, and did not depose any key witnesses. She has known about these key witnesses for years, even though the TikToker claimed that she needed more time to prepare for the therapist. They responded that, again, has known since November of 2023, and she never attempted to depose or investigate that specific testimony. They also file that the TikToker has repeatedly attempted to delay the case through motions to dismiss, reassignment motions, reconsideration motions, and other filings, and as well as not continuing the trial would cause major problems, mainly disrupt the court schedule, waste trial preparation already done, and inconvenience any witness that has to come down to Boise, Idaho. So she's had a lot of time, and the main issue that the lawyers see is that she just wants to delay more and more because she doesn't want this to go to trial. And when you look at all of these motions, mind you, 147 documents are in this alone. Like 147, including the last little bit of trial. I think in total there's like 148, and one of them got kind of removed or at least just excluded. Half of them are just the back and forth and fighting between the TikToker and the lawyers to even get this in front of the court alone. February 11th, the TikToker then files a motion in reply of the memorandum. Again, the TikToker kind of repeats the same argument that the court does lack jurisdiction. The TikToker again argues that the federal court does not have the jurisdiction. The professor allegedly cannot prove that the damages are over $75,000, and without those damages, the case should not be in federal court. The TikToker does claim that the professor's damages are based on fabricated or false evidence and essentially related to mental health damages. She also does bring up claims that the PTSD diagnosis is invalid. So a major part of this reply focuses on the professor's PTSD. The TikToker argues that the PTSD diagnosis requires a traumatic event under the DSM-5, and allegedly defamation cannot qualify as a traumatic event. The diagnosis was made by a psychotherapist and not a psychologist or a psychiatrist, and because of that, the TikToker then argues that the PTSD damages are not legally valid. She then goes on to claim again that the damages and the evidence of that is fabricated. The TikToker claims that she prevented false evidence of damages, falsely claimed mental health harm, and cannot show actual damages. The TikToker argues that without these damages, that the court cannot maintain jurisdiction and that the case should be dismissed. She also challenges the summary judgment ruling. Now, the TikToker has argued this a few times, but again, she's arguing that the court should not have granted summary judgment of the defamation, and the TikToker claims that Professor allegedly failed to provide key elements of defamation, including proof of reputational harm and proof that TikToker intentionally made false statements. Again, despite this, though, the court did rule against her earlier in that case, all the way back in 2024. Mind you, the ruling came down in June of 2024. She is still trying to argue this in February of 2026. Her last little chunk of this motion is to request a continuance to allow an appeal. So TikToker again asked the court to delay the trial so she can pursue an interlocutory appeal if the motion to dismiss is denied. She argues that the delay is necessary to prevent irreparable harm, as well as challenge the court's authority to hear the case. On February 15th of 2026, we are about 10 days away from the trial almost. The judge does sit down and finally rules on the TikToker's motion to dismiss and the motion to continue the trial. And as a result of both motions were denied. So the first motion to dismiss was denied. Again, she was arguing that it lacked jurisdiction due to the damages. Federal jurisdiction does depend on the amount claimed in the complaint, not what damages might ultimately be proven. So if you make the lawsuit and you say, hey, I think there's $75,000 worth of damages and I think we should stay in federal court, until you go to trial, that can't be proven. Because if you can constantly show that there were all these amounts of damages, it could lead up to $75,000. Dismissal only happens if there is legal certainty in the fact that $75,000 is way too much for whatever damage is caused by this specific defamation. And that standard was not met. The main thing that the judge kind of harped on in this particular motion was that the TikToker has made this argument twice already. Once in November of 2023 and once in February of 2025. And this motion has raised no new arguments, so there is nothing new to rule on. And the court also clarified that the stage of case that it was on. By February of 2026, the liability had already been decided since June, and the only issue left was how much money for damages was to be received. There were to be no disputes about damages in front of him, but in front of a jury instead. He also talked about the PTSD argument, and that was also rejected. Again, TikToker alleged that the professor cannot legally have PTSD from defamation. The judge ruled that, again, the argument challenges the evidence, not the jurisdiction, and whether PTSD is valid is a jury question. The court has already ruled that Schofield's fit therapist can testify about the diagnosis and the treatment. He also ruled on the punitive damages, and that was, again, rejected. The court had already ruled that the professor may seek punitive damages, and whether she actually proves them is up to the jury. So this cannot justify dismissing the case. And then the motion to continue trial was also denied. So the TikToker asked to delay the trial so she could prepare more and possibly appeal. The judge's reasoning was that the request came too late. The main facts that he emphasized were that the trial date had already been set for 6 months, the case has already been pending more than 3 years, and that the TikToker filed the dismissal motion less than 3 weeks before the trial. So judge was not too happy. He did file and denied pretty much everything, but it's only the beginning. It's only the beginning. So on February 18th of 2026, there was a plaintiff's request to take judicial notice. Pretty much what that means is that the professor asked the judge to take judicial notice of the 3 official court documents related to Brian Kohberger, who was the accused and later convicted killer of the Idaho 4. Pretty much what judicial notice means is that the court accepts certain facts that are true without needing testimony due to them coming from a reliable public record, i.e., the Idaho court system. There are a couple of exhibits that were attached to it, mainly Exhibit 22, which was the indictment that showed that he had a grand jury indictment of burglary and 4 counts of first-degree murder, and it does include the names of the victims. Exhibit 23, which was his plea agreement, where he did plead guilty to both crimes, and he also agreed to a fixed consecutive life sentence for the murders. And then Exhibit 24 was the judgment of conviction. So this 3rd document was the final judgment for the Idaho court, confirming that Kohberger was convicted of burglary and 4 murders, and that he received 10 years of burglary and 4 life sentences without parole. So they're trying to admit this into the court because they're arguing that the facts are that Kohberger was charged with the murders, Kohberger pled guilty to the murders, and that Kohberger was convicted and sentenced for those murders. Now, these facts are obviously relevant because the TikToker's videos claimed that Professor was involved in the murders, and the conviction shows that the real perpetrator was already identified and convicted, undermining the TikToker's claims. Later on in the filing, the lawyers also state that they tried to get TikToker to agree that the exhibits were authentic. The TikToker never gave a clear answer, so they just filed the motion asking the court to recognize them. And they also included an email between the TikToker and themselves to prove that they tried. On February 22nd, the pre-trial memorandum by the TikToker was submitted, and then the pre-trial hearing conference was on February 23rd. He did grant the plaintiff's request to take judicial notice, as well as the exhibit list that was amended by the TikToker was submitted. And then we just hop into day 1 of trial, which is February 24th. I unfortunately was not there, but I do have court notes. So we're going to go through court notes really quickly. And then as certain things are brought up, I will either put them up on the screen of what the exhibit was, or we will talk about it at another point. So there is no reason to bring it up now because it probably becomes more relevant later on in the trial. So it starts at 8:36 in the morning. The judge does welcome the prospective jurors. He explains what jury service is and introduces the parties and summarizes the case. So all jurors in that courtroom are sworn in, and then there's a voir dire of the prospective jurors. And then obviously over time, certain jurors are excused for certain causes, and each of the counsel executed certain challenges and then passed the jury for cause, which pretty much means that they found the jury reliable, they found out that the jury should be good to go, and there is no prejudice against them. So that specific jury was sworn in to try the cause at issue. A preliminary instruction was read, and then the judge admonished the jury for the lunch break, which pretty much just means they're free to go for lunch and then come back later. The first witness for the plaintiff's case is the professor herself. Since she is the one bringing the claim, she is the one that has to present the case in chief first, and her lawyers decided to call her first. So opening statements were made by both counsel and the defendant or the TikToker. And I will say this, I tried to grab the transcripts of the opening and closing arguments because I thought the closing arguments were so good by the professor's lawyers that I really wanted to get them so I could read them to you. Unfortunately, because there is a 90-day hold period, I am unable to access them right now. It is only parties and the parties to the cause and attorneys, I believe, right now. But once they're unlocked, I should be able to go and get them. So if you're interested in that, please let me know down below. And maybe we can do something over live or something where we read the transcripts. So then the testimony of the plaintiff's witness, which is Rebecca Schofield or the professor, then steps onto the board. So they also admit certain exhibits with no objection. Later on, there is a continued testimony of the professor, and other exhibits are later admitted, some with objections and some with not. So the main two that were objected over is Exhibit 32 and 34. They were both offered, but the objection was over authenticity or relevance, and they were both overruled. One was admitted and one was taken under advisement of the court. But Exhibit 32 is the physical therapy statements and receipts. And that one was overruled and admitted. And then 34 was the professor's medical center clinic visit receipts, and that was taken under advisement by the court. Later on, 35 and 36 were both offered, and that's one for the therapist treatment receipts and another one for the massage therapy receipts. After some time, then the judge later admonished the jury for the evening, so they let them go. And about 8 till 5, the jury was not present, but the court and parties discussed remaining trial schedule, jury instructions, and any objections to exhibits. The court denied most of the objections for the defendant's exhibits, which is 506, 508, 509, and 510 for reasons stated. And then the defendant to file her jury instructions by that night at 8 p.m. And then the jury trial was to resume back on February 25th of 2026. Trial day 2, February 25th. Professor Schofield is still on the stand. And they've had to make it abundant multiple times that this is a damage trial, not a liability trial, because liability for defamation was already decided. But apparently the TikToker couldn't get it through her brain that it was already decided, so she continued. So court resumes with Professor still on the stand, and actually, the TikToker steps up to cross-examine the professor herself. The TikToker introduced the defendant's exhibit, which is 519, and it was introduced and admitted. And then again, her medical certificate, which was Exhibit 34, was also admitted. So the main cross or questioning was trying to imply that the professor was still behind the murders. And she repeatedly asked questions that would try to reopen the liability issue. And it was just, even though even with the lawyers constantly objecting to it, being like, hey, this is for only determining damages, she tried very, very hard. TikToker also focuses heavily on whether the professor had support or not. So some of the main ones are about the support from the American Federation of Teachers, the union support, and then she asked if she had any financial support from the public or any public support online. I think she was mainly trying to use this line of questioning to get the professor to admit that she wasn't truly harmed by those videos. So they go into the exhibit document 519. So the exhibit document 519 is the GoFundMe for the professor. She spends a lot of time on this specific thing and on questioning the professor about this specific thing. The GoFundMe was created by a friend. It was raised over $22,000, but again, donations were paused after the judgment in 2024. The professor did not write the fundraiser, and the fundraiser was only meant to help with legal costs. But she does ask some interesting questions. So her main asking was if she ever read any of the donor comments, and she also harps on some specific comments from 2 years ago. I unfortunately did not get those questions, or the comments, I guess is the right word. But because I'm nosy, like I think some of y'all are, I did pull up the GoFundMe. We gotta be nosy together. I will say, don't touch the poo. I'm only doing this because I'm reporting on it. Don't touch the poo. But there are a multitude of different comments here. But she started harping on a few that were from about 2 years ago. And what was very interesting, because I didn't get the comments down, but when I went to go look, there's a lot of them that are just talking about, hey, we saw you on X, Y, and Z YouTube channel, so we wanted to come and help. But there's this one particular one that I think is the one comment that probably rubbed the TikToker the wrong way. And it says, a woman's life and reputation shouldn't be ruined because a pathetic little girl wants fame, and I doubt the professor will get her legal fees back. Just sorry, I can't afford more. I'm pretty sure that's the one comment that probably rubbed her the wrong way. I'm fairly certain that it's that one. I could be wrong. Fairly certain though. Just saying. Then we move on to the TikToker questioning the professor about social media. The main topics that were raised were the professor withdrawing from social media, privating all of our accounts, stopping posts, as well as viewing content but not posting, and whether the university helped that lockdown with the accounts. The professor then explains that she withdrew due to harassment, and the university advised privacy measures. The goal was to protect her family and her children. And then they get into safety concerns. Now, I've kind of have not said what the accusations are. They've come up in some of the legal things that I've talked about. Well, I don't have any of the videos, and I'm kind of glad I don't, but it's just kind of hard because you don't understand the safety concerns until you start talking about the wider breadth of everything. The main accusation, as we've seen multiple times, is that the TikToker constantly accused the professor of orchestrating the murders of the 4 University of Idaho students. And she orchestrated the murders and had another male student, which was then ex of one of the victims, to carry out this murder. Yes, another party that was not even involved at all was also brought into this. And then when the actual convicted killer gets arrested, then she changes her story and almost shows sympathy to the killer and says, well, no, he didn't actually do it. They're just looping him in because they can't prove that the professor had done it. And the main reason why she thought that the professor had orchestrated or were a part of these murders was because she believed, due to her tarot cards, that she had an illegal affair with one of the victims, one of the female victims. And it's kind of gross, especially when you're shown documents of all the hashtags she used, all the stuff she said on top of her videos. It's just gross. And the safety concerns is like kind of where I wanted to talk about this in general, because she testifies how she feared that people believed all of these accusations, that people would act on these accusations, the loss of anonymity and the potential threats to her family. She has children. She has a husband and children who really shouldn't be affected, but are now. And she lives a whole different life because of these accusations. And the fact that these accusations label her a murderer and also accused her of sexual misconduct with a student that she never had any engagement with. None of the victims were ever in any of her classes. So, in all reality, how? Especially when you have a plethora of evidence showing that she never engaged or even acted in any way, shape, or form towards these videos. But the professor later implies that implying a relationship with a student is effectively accusing her of abuse of power. And that's kind of where she leaves it at with safety concerns. They do dive in a little bit to the medical issues that the professor experienced. The key points were that the symptoms began in December of 2022, that treatment began in February of 23, and a lot of the symptoms included headaches, nerve compression, hip pain, shoulder pain, dizziness, and neuropathy, and there were medical records that were presented as payment records, but not a specific diagnosis. But then the professor was excused from the stand after questioning ends, and then the court does take a brief recess. Okay. After the recess, then the plaintiff calls the TikToker. So the TikToker takes the stand, and one of the lawyers takes over the questioning. So we first start off with mainly background questions, and the topics were like where she lived, the travel history, the social media use, and the TikTok experience. Some of the more important admissions were that she understands what hashtags and social media promotions do. She had posted multiple TikTok videos accusing the professor, but she had never met the professor before the actual trial. And then there were multiple TikTok videos that were shown in court in front of the jury, and the TikToker does acknowledge posting them. To say that the jury was uncomfortable would be an understatement. It was very surreal to watch them because you could tell that the comments just rubbed them the wrong way. So a lot of the claims, again, in the videos were that the professor orchestrated the murders, that the professor had an affair with one of the victims, and that the professor hired another person, i.e. the male student, to commit the killings. The TikToker does at one point claim that the videos were manipulated, and the court does take a small break to address that claim, but then the videos were played again. Even though she does claim that the videos were manipulated of some sort, what is so intriguing to me when I look back through the actual court notes as well is that there were no objections at all to any of these, and most of them are TikTok videos, and they get offered in without any objection, which is just absolutely strange to me, but everybody has their own way of doing court, I guess. They later move on to some of the exhibits. Exhibit 10 is a screenshot photo of her video showing the shares, the likes, and the comments. And the attorney does highlight this, that the TikToker used hashtags to amplify the post, and some of the examples of the hashtags are University of Idaho, the names of the victims, Idaho murders, and the professor's full name. And mainly the point for this specific line of questioning was to show that the videos were intended to reach a wider audience. They go on to talk about the videos and how she has refused to remove the videos, and the TikToker does claim and confirm that she never apologized to the professor, never voluntarily removed the videos, and that the only reason why they were removed because TikTok removed them themselves. She also admits that she created another account after her first one was being banned, and she continued to post about Schofield. So they do dig into her travel and lifestyle a little bit. The lawyer mainly questions the TikToker about travel, i.e. trips to Europe, Italy, France, Thailand, shopping, vacations. And the main purpose, I believe, for this was to show not only her wealth, but also to show her lifestyle between that and how she kind of was living this life and living so great while also harming the professor and the professor unable to live her life. Now, here comes a little bit of the weird part. Because the TikToker is being pro se, which means that she is representing herself, she has to question herself. I'm not lying to you, and it's very odd to watch. So she has to conduct this cross-examination in an interesting way. She has to sit at the witness stand and say question and ask a specific question and then go answer and then answer as if she's the witness, which she is. It's a very, yeah, she has to ask herself in third person and then she has to answer herself, and it's a little weird. But the TikToker explains how she reached her conclusions. She states that it was through tarot and oracle card readings as well as spiritual intuition. And the process that she describes is that the TikTok readings were about the murders. The history was constantly repeating in the cards. So she interpreted it as a teacher. So then she decided to go to the University of Idaho department, the history department website, and scroll through the faculty members until she felt a pull towards a specific person or did a reading on each person until she hit the professor. And then she concluded with her readings that the professor was responsible. I'm not lying, and I wish I was. That is how she got to the conclusion of the professor actually being, the professor supposedly being the one to orchestrate the murder. But according to her, she did. And it's freaking disgusting. So she decided that she wanted to post about these accusations, and she explains that she truly wanted to help. She says that a TikTok user from the Moscow community requested a reading, and she believed that the public needed to know that this person was in their community and she's the one that orchestrated the murders. And she also explains that the reason why she had so many videos, again, 114 videos, was because the TikTok length at the time had limits and they were only 60 seconds each. That's literally why. But she says that she truly believed that the readings were true. They do enter an exhibit, which is 512, which is the FBI tip line. And the TikToker states that she submitted the tip to the FBI and emailed law enforcement as well, and she believed that the investigators should verify her claims. She also stated that she never received a response, and then the exhibit itself is just the email that she submitted. The judge then has to give a clarifying instruction, which pretty much is to state that the TikToker's testimony should be understood as a way to describe her mental state during this time and not as a proof of the events that she described. So then it was redirection after she finished her cross, and the attorney stepped back up and begins to question the TikToker again. What was very interesting about this recross is that the lawyer, her name is Wendy Olson, actually was able to get some important admissions in. Mainly that the TikToker had no factual evidence. The TikToker conducted no investigation. She did not verify the professor's location during the murders, and she relied entirely on tarot readings. But the TikToker kept saying, and this was for multiple times, like even in her closing statement, the TikToker continuously says that psychics rely on intuition, not facts. And it was said multiple times without fail. And when I tell you multiple times, it was probably like 30 by the time the trial was done. The lack of evidence was also confirmed. So the lawyer really did harp in that the TikToker had seen no documents linking the professor to the murders, that no investigation had ever identified the professor, and that the only charged suspect was Brian Koberger. The TikToker does argue that documents might exist under seal, but confirms that the TikToker has never seen them. And then the TikToker was excused from the stand. So they did have 2 more people come through. The first one, I'm not going to say their names just because the only thing that they really had substance for was just to bring in certain exhibits. And the main exhibits that were entered in through them were the Professor's Exhibit 27, which is the subpoena to produce documents, information, or objects to permit inspection of premises in a civil action to the University of Idaho in response. And then the TikTokers exhibits, which are 508 and 509, which is the U of I public records request and the U of I denial of records, which was kind of argued back and forth, but she could have at any time asked the plaintiff for those records, but she did not. So at the end of the day, again, the judge did dismiss the jury for the evening, discusses the possible jury instructions with the attorneys, and then schedules the trial to resume the next day on February 26th. This one was a doozy. And when I mean this day was a doozy, I mean my face was facing so hard that at one point I just had to look down and not look up from how disrespectful half of this line of questioning ended up being. But kind of go through the first context of it all, and then I will explain to you some of the stuff that went on. So again, day 3, and Dr. Rebecca Talent takes the stand. Now, the reason why I am specifically saying their names is because, one, they are public figures. They are mainly public through, especially Dr. Talent, she is public through academia, and she's been in academia since the 1970s. So a little bit of background about her. She has a long career in studying public perception and media impact. She worked in public relations and academia since the 1970s. She fully got her doctorate in 1995, and she's also a former professor of U of I, where she later retired in 2016. And she created that entire department of public relations and communications. So any of those classes you take up there, she most likely had a major hand in creating those. So some main points in key testimony. She mainly explained how public accusations online can damage a person's reputation. The reputation is massively important in academia, and false allegations can damage a career even if they are later disproven. And reputation recovery can take decades upon decades. The main one that she references is the 3 Mile Island. And if you don't know what the 3 Mile Island is, for a quick context, it's mainly about this nuclear plant that had this massive issue. And for over 40 years, they had these public relation issues where no one wanted to live around there, and they had to fully shut it down in 2019. So her main point was that damage doesn't have to happen immediately, and it can appear years later. The main academic reputation risks that she described were loss of credibility, students avoiding the classes, gossip spreading through universities, online harassment, and reputation damage among peers. She focused mainly on student gossip and how that alone can cause students to drop classes, lead to online harassment, and damage professional credibility. She has brought up a few times that students will make websites about them too. So then it's time for cross-examination by the TikToker. So the TikToker tried to argue that the professor did not lose her job. She still had academic support, and therefore there were no real damages. But Dr. Talent kind of responded that damage is not always immediate or measurable, and reputational harm can develop slowly over time. She also testified that she personally observed that the professor was experiencing severe emotional distress, and the situation caused physical and emotional distress. And I will say, not to give credit, but I will say that there were certain pieces of questioning that the TikToker got right. She was bringing up how the situation with the professor and the 3 Mile Island were connected. Because even though the 3 Mile Island was all about public relations, everything was about public relations. There was no defamation. There was nothing that would tarnish the name that hadn't already been tarnished due to backed evidence. So I thought that was a good one to kind of get a leg on, but she ruined it right away when she started to almost talk down to Dr. Talent and pretty much say that, well, your testimony doesn't mean anything because you want to use this specific example. When in reality, this woman had seen her perform in academia at the U of I and knew her career and how her career was handled, and still had people that worked there that told her that she was losing opportunities and so on because of these accusations. So She had a few good points, but she mainly missed the mark, and it was very interesting to watch. But after all of that, Dr. Talent was excused. We took a mini break, and then the mental health therapist stepped onto the stand. Now, I have a lot of thoughts. So I'm going to go through her background really quickly, and then we're going to get into the cross-examination. And when I tell you that this was brain melting for no reason, it was brain melting for no reason. All right. She is a licensed mental health counselor. She has about 32 years of experience, maybe a little bit more. And she worked in a crisis intervention and family services before she moved to a private practice in Moscow. So she started treating the professor in May of 2023, though the professor initially did reach out in January of 2023, but due to her full schedule, she wasn't available until May. So they met every single week until their schedules started to not mesh very well. So then they moved to twice a week, and each session was about 60 minutes. The professor self-reported to the therapist that she came to therapy because of the TikTok accusations, which was causing fear for herself and her family, and that she was struggling emotionally dealing with this. A lot of the symptoms that were described by the therapist were severe anxiety, intrusive thoughts, constant fear for family safety, checking locks and windows repeatedly, insomnia, emotional distress, and lack of trust. She also testified these symptoms matched the PTSD criteria. So the therapist testified that Professor had no prior psychiatric history, and that the diagnosis was confirmed using the DSM-5 diagnostic criteria, and that the PTSD diagnosis was confirmed within days of evaluation and repeated evaluation in 2024 and 2025. So the treatment did include CBT, or cognitive behavioral therapy, and ongoing coping strategies. The therapist also testified that the professor's PTSD symptoms worsened when TikTok posts continued, and the symptoms often intensified around anniversaries of the murder and of the videos, and that the professor still shows severe symptoms today. So her professional opinion, mind you, was that the professor will likely require long-term treatment. And with that, cross-examination started. I'm gonna preface this with a few things, right? Trying to make an expert witness look stupid only makes you look stupid. To sit there and focus on one paper for almost 2 hours is wild. Mind you, she has been doing this for 30 some odd years, and she worked in a very high-paced environment. She worked in ERs as well, and she worked in a very high-paced environment. So focusing on one specific question from the DSM-5 is wild. The TikToker's main argument was that the professor did not have PTSD. She did not directly witness a death. She was not physically present at the murders, and that TikTok videos cannot qualify as traumatic events. This is probably one of the only testimonies that I will actually go into in detail because this is ridiculous. So what happened was they kept going back and forth about the DSM-5. Now, for anyone who has been diagnosed with PTSD or dealt in some way, shape, or form with people having PTSD, they know to an extent what the DSM-5 and what the criteria are. I have the DSM-5 pulled up. She harped on this specific first page. And when I mean she harped on this, she focused only on letter A and went through each number. And she read the thing, and she goes, exposure to actual or threatened death, serious injury, or sexual violence in one or more of the following ways. Directly witnessing the traumatic event, witnessing in person the event as it occurred to others, learning that the traumatic event occurred to a close family member or close friend. In cases of actual or threatened death of a family member or friend, the events must have been violent or accidental. And experiencing repeated or extreme exposure to adversive details of the traumatic events, i.g. first responders collecting human remains, police officers repeatedly exposed to details of child abuse. And then in bold, note, criterion A4 does not apply to exposure through electronic media, television, movies, or pictures unless this exposure is work-related. All right? So, for almost 2 hours, They focus on this specific question. That's it. And then they go, and because she thinks that she got one over on this therapist, she goes, well, explain what death is to me. Explain what this is to me. Explain what threatened death means or serious injury means. Ma'am, the first TikTok you made of Professor Schofield was thoroughly showing her full ass fucking photo along with where she worked at and her phone number. That is now considered work related because every time she goes to work, she is under a perceived threat. It's wild because you sit there and you're like, oh, well, technically, this is not, a work related issue. No, it is now because you made her work a part of the issue. So now every single day when she goes to work, she has to worry about someone getting on campus and harming her. It doesn't matter on any level of what you perceive is work related or not. It is now work related. And what butters my biscuit, for lack of a better term, is the fact that she has PTSD as well. The TikToker has PTSD as well. And yeah, just wait until she talks about it or we talk about it from her testimony because, ooh, okay. So it becomes a very contentious part of the day. So the TikToker tried to argue that the professor could not have PTSD because she did not directly witness the death. She was not physically present at the murders. And again, the TikTok videos cannot qualify as a traumatic event. But the therapist then explains that PTSD can result from repeated exposure to traumatic accusations, that the professor experienced ongoing psychological harm and being accused publicly, mind you, of a quadruple homicide did create a continuous trauma. She stated that repeated accusations seen by millions of people can be psychologically traumatic and can technically fall under this diagnostic criteria. So what was interesting was that the TikToker repeatedly interrupted the witness. There were arguments over the DSM-5 definitions, and that continued for a long while, to the point where the judge had to call multiple breaks and sidebars. And pretty much the key conclusions from the therapist, mind you, after 2 hours, was that the professor didn't meet the criteria and that the trauma is tied to ongoing public accusations online, which also attach to a work-related trauma. Yay. Finally, after all of that, we move on to another witness, which is the professor's best friend. So the background is that they're a close friend of the professor for over 20 years, and they watched the TikTok videos when the professor first discovered them. So the first discovery of the videos began during Thanksgiving of 2022, where the professor called him upset and said that she had been accused of murder online. He then decided to go searching and watch the videos. He then testified that the accusations were disturbing, that the videos had large view counts, and the online discussions about the murders were extremely intense. And he believed fully that the videos put a massive target on the professor. So then Exhibit 13 comes in. Now, Exhibit 13 is an exhibit that has 58 pages full of videos that the TikToker made from about November, I believe 23rd, all the way until I want to say when the actual lawsuit happened on December 21st. And that's where the 114 videos are about. And I could be very wrong. I want to say it's probably less than that, but I believe that's the time scope. It was from the 23rd up until December 21st. He described the impact and changes on the professor of constant anxiety, fearing that someone might act on the accusations, and repeated discussions about safety. He said that the entire situation just felt massively uncomfortable for all of them. Okay, so then the TikToker steps up for cross-examination, and she starts off strong. She says that this friend is biased He is not a medical professional, and therefore he could not evaluate the professor's anxiety. Wow. Seems like you don't believe the professional, and if there isn't a professional, then they're, well, accused constantly of not knowing anything because they're not a professional, but apparently even the professional doesn't know anything, so who does? Not the point. He then responded that he had known her for decades and he clearly could see the changes in her behavior. And that's kind of where their testimony ended. And then finally, the last two witnesses of the day were the professor's husband and the professor's mother. So the husband, they had been married since 2012 and they do have 2 children together. He does describe the life before the accusations of motivated, highly professional, passionate about teaching, and very family focused. And then he said that during the discovery of the accusations that she asked them to watch the videos and he warned her that they were very disturbing. There were many safety changes in the household, so the family began to lock the doors constantly, install security cameras, installing motion lights, changing school pickup routes, and avoiding public outings. And the actual receipt for the home security system was then admitted as Exhibit 37. The husband then testifies that the professor lost sleep, frequently checked doors and windows, and worried about the safety of their children. He said that the accusations caused the family to feel targeted and very unsafe. After Koberger was arrested, he said that the family had finally had hope that the accusations would stop, but sadly, the TikToker continued to post videos incorporating now Koberger into the conspiracy narrative and still blaming the professor. And then Cross. So the TikToker questioned why they did not install the security systems earlier, whether anyone actually attacked them, and whether their fears were hypothetical. Yes, she did ask that. The husband then answered that the fear came from being publicly accused of murder online, and anyone might believe the claims. There were a few times throughout different testimonies that the death threats were brought up, but what was so interesting was that they were just brought up in passing, like, oh, the professor told me about them in a conversation. And then the TikToker would harp on it. Okay, well, do you have evidence? Do you have an email that they did that? Or do you have this? Or do you have that? Or blah, blah, blah. It's like, ma'am, it was probably a comment on your TikTok video saying that they're going to go kill her or something of that nature. Like, death threats come in all forms, whether verbal or online, through email, through comments, through videos. It is a wide berth of many, many things, but it was very interesting to see her harp so much on that when 9 times out of 10 it was just someone being like, yeah, she had a death threat. Oh, well, did you actually see it? Did you see this? Did you see that? It was in a video or a comment or something of that nature that might not have documentation. Or maybe it's just said in passing. And then the final witness of that day was the professor's mother. It was a very emotional testimony. The mother described learning about the accusations and seeing how her daughter was just devastated. She did break down into tears while testifying. She said that her daughter became very fearful, withdrawn. She was exhausted, emotionally distressed, and that the family also began carrying a handgun when visiting, and they followed stricter security protocols. She also testified to the long-term health effects, saying that the professor later developed chronic headaches, neuropathy, diabetes, and severe fatigue. She said that this had become her new life. And then cross-examination. TikToker questioned whether anyone physically attacked the professor and whether the family's fears were real or not, which the professor's mother responded and said that harm came from falsely calling her daughter a murderer to millions of people. So some of the stipulated facts that did come out this time to the jury was that Koberger was charged in May of 2023. He pled guilty and he was sentenced in 2025 for the actual murders. And after that, day 3 was done. He dismissed the jury for the evening, and they discussed final jury instructions before they set the trial to resume the next morning on the 27th. Final day in trial. So, starts off chaotic, all right? I really thought that this court case couldn't be as crazy as it was. Every day shocked me to be more crazy. So on the morning of the final day, the jury is brought into the courtroom like normal. And when you are on jury service, You have to sit there, and the judge will ask you every single morning, did you see or hear anything on TV, phone? Did anyone try to talk to you about the case? And blah, 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 blah. And normally it's no, I was good. Everything was Gucci. Not this morning. Um, this morning, a juror raised her hand, and the juror spoke up and said that she had seen something on social media. So he goes, I'm going to pause you there, and had the rest of the jury step out of the courtroom. And then juror remained in the court, and they had to conduct a short voir dire of the juror, mainly to see what she saw, if she clicked on the post or not, whether she actually read the article or not, and whether the exposure would affect her ability to remain impartial. Now, she said that she was scrolling Facebook, she just saw the headline, and it appeared to be from some news station on social media. She did not look at the article or open the article. All she saw was a photo from one of the videos that was shown in the courtroom on previous days, and that the headline mentioned the TikToker being famous. She said that she scrolled, as soon as she realized what was going on, she scrolled right away from it and did not actually click or read the story itself. After they conduct that short voir dire, he asked the juror to step out, and then he asks the lawyers and the TikToker what to do moving forward. Mainly, he asked them if he believes that this now creates an issue of her impartialness. The lawyers said no, because she didn't click the video, she didn't click anything, and anything that was even possibly stated in the headline she already knew about. While obviously the TikToker said yes, the juror should be removed. Mainly saying that, well, yeah, she said famous and she said this. Pretty much stating that because she only saw part of the photo in the headline, that she should be removed. The judge's ruling was that the juror had not read the article, and the juror only saw a headline briefly, and the information did not introduce anything new beyond what jurors already knew in court, and that the juror stated that she could remain impartial. So he did overrule the TikToker's objection and allowed juror to remain. So then they have the full jury brought back in, and the trial proceedings then continued. So when the trial proceedings continued, the professor's lawyers stood up and said that they are now resting their case, which means it is now the defendant's or the TikToker's turn to present her case. I'm not lying you when I tell you that on her witness list, it was just 4 times of her name, and she only called herself. So she calls herself as a witness, and since she is testifying pro se, she has to ask herself the questions and answer. And yes, if you think it's as weird as it looks, it is. Question: describe your work. Answer: well, for a job, I do X, Y, and Z. So she talks about how she runs her own business, as well as helps those with low to middle income with taxes, and small businesses with any LLC, HR, and anything in between. She has claimed that her income is anywhere between 20 to 30, possibly yearly, from the business. She didn't say yearly, I'm going to assume. And then she is 100% disabled through the VA, so she receives that monthly check from the VA as well. She did give some personal background, and I'm going to say this with as much love in my heart as possible. Seeing someone who is a veteran struggling with stuff that they saw during deployments is tough. I am a veteran myself, and sitting down and having conversations with people about stuff that I've seen myself on deployment can be tough. And struggling in that is nothing new in the veteran world. Finding some way to manage that pain is what a lot of people do. But it looks interesting when you're sitting there and you're talking about your military experience, which I'm never ever going to question someone's military experience, because everyone has something different. But to sit there and claim that someone doesn't have PTSD because of something else is truly disgusting when you know the struggles of PTSD and you think you could look at someone and tell them that they don't have it. She talked about her military experience, she talked about her deployment experience, and then she claimed PTSD from witnessing deaths during service. She is disabled through the VA. I have no doubt that it's probably on her VA records. She then testified that she began her spiritual journey after leaving the government to work, and she studied tarot cards, Buddhism, Hinduism, and numerology, and claimed that she trained herself to read tarot cards. How she explained that she taught herself was to do tarot readings, predicting outcomes of TV shows, intuitive messages. And she mainly talks about a lot of times how feelings are like a GPS direction. And a lot of times she would say, like, oh, I would feel this way about something, and then this would happen the next day. Pretty much just trying to handle how her psychic intuition started. She then submitted a slew of her exhibits, and most of them were text messages used as alleged proof of intuition. It was a text change between her and her aunt saying, like, hey, I had a dream that I was taking over the lease, which means there's a possible eviction. I'm worried. And her aunt pretty much telling her, no, it's fine. It's fine. You don't have an eviction. There's no eviction, which she said later that there were documents sent to her that were shown to be eviction issues with her aunt. And later they were dismissed. But she said, well, I should have trusted my intuition. There were chunks of a book that she wrote where she claimed to have solved a murder in under 24 hours. She also added in subpoenas attempting to obtain information about the murders and requests that were sent to Meta or Facebook, the Moscow Police, the University of Idaho, and Ada County. It is Ada. It's not ADA, it's Ada. Investigation attempts that happened after the accusations. So the TikToker then testified that she attempted to prove her theory after posting the accusations. Actions that she described were sending a tip to the FBI. She posted YouTube videos explaining her theory. She attempted to subpoena Meta for private data. She also sent request records from the police department, the U of I, and sealed court documents. She also attempted to obtain phone records, financial records, DNA evidence, victims' bank records, autopsy reports, info on the abandoned white Elantra, as well as not only all those records from the victims, but also from those that she thought pertained in this actual lawsuit itself. Most requests were either denied or just outright ignored. She then pulled up Exhibit 13, which was the 114 TikTok videos referencing Professor Schofield. And a lot of these videos, if not all of these videos, had the professor's name in the actual hashtag line. And the TikToker testified that a lot of these videos were not about Schofield, and others were just tarot card readings and not statements of fact. But mind you, she only picked the first 10 pages out of this 58-page document. I had to quickly go back through some of my notes because I really, really wanted to go and tell you what she did. So she grabs the first 10 pages and then she goes video by video until she ends up realizing there's a lot of video. Then she goes page by page. So the first video is about Schofield, no, just about students, which was from November 23rd. The second video, yes, about her. Video 3, 4, yes, about her. Video 5, 6. 5 is about the professor, 6 is not. Video 7, 8, not about her. 9, 10, not about her. 11, 12, not about her. 13 and 14, 13 was a repeat video, but 14 was not about her. I'm assuming the repeat video was about her because she didn't specify. 15 and 16, not about her. 17, 18, not about her. And then 19 and 20, not about her. About the professor. But if you look through all the hashtags, they all had her name in it. So then we go into cross-examination by Ms. Wendy Olson. Then we go into cross-examination by Ms. Wendy Olson, which is, again, the professor's, one of the lead attorney, or is the lead attorney, if I'm correct. And she proceeded to ask the TikToker about her book. The TikToker claimed to have wrote a book TikToker wrote a book claiming that she solved a mysterious death under the name Ashley God and claimed that she solved this case in under 24 hours. So what was very funny about this was that she zoomed in on the copyright and it was like Live in Fantasyland LLC or something. And then the heading was Ashley God. So the lawyer actually dug into this death specifically. And the death happened in 2018, where in 2019 it was labeled an accidental death. It was not labeled as a murder in the very beginning. And as a result, a lot of people over time started making a big ruckus about that. And in June of 2020, it was later reopened because of some celebrities and other people's making a massive stink about it to have it reopened and possibly reinvestigated to see if it was a murder or not. So then it later closed in July of 2021 with no criminal charges, and no person has ever been charged. I don't even know if it's still considered accidental or not, or if they removed that from their from her death record specifically or not. And really quickly, for those of you who do not know what this mysterious death is, this is the mysterious death of Tamla Horsford. I hope I'm saying that right. Tamla Horsford. And this is the mom of 5 that would go to the football mom slumber parties, and she ended up dead in the backyard of one specific slumber party. There have been a lot of claims that circle around that specific death. It is wild, so I would highly suggest checking that out, seeing what's going on with that, because I have not looked into it fully. I just remember hearing about it. But this book specifically is what they're talking about, where it was Solving Mysterious Deaths, Part 1, and it was all about this murder and who supposedly killed her. Again, this is all alleged because there has been no one charged for her murder. So, you want to give that case a look, please do. It's very important because if this was a murder, then we definitely need to look into it again. I hate to switch it up so quick, but then she goes into traveling and spending. So they showed 4 minutes and 30 seconds of her Instagram stories of her showing all these different travels to Italy, France, Thailand, and London, as well as luxury purchasing items, i.e. designer items, Chanel products, expensive perfumes. And I truly think this is just to show that she has no hardship, that she is able to pay whatever the jury decides to have her pay. What was very interesting too is at one point there was a part of the Instagram stories that they were showing, and it was of her in Thailand doing like a money fan, and they asked her what that was, and she goes, "Oh, that's my rent money." And they're like, "Oh, well, how much is your rent?" And she said anywhere between 2,000 to 22,000, depending on the Thailand baht, their currency. And I thought that was just interesting to take an Instagram video of you flashing your rent money the way you did, but do you, I guess. That is your choice. But some of the key admissions by the TikToker during this cross-examination was that she did not have factual evidence linking the professor to the murders, that many statements were just based on tarot readings, and she continued posting videos even after the cease and desist letters, and she still believed that the professor was involved. Now, I didn't touch on some chunks of it just because some of it's just weird. Like, the way she handled this whole situation was just odd in general. But there was at one point where she took, I want to say it was the actual cease and the second one, the cease and desist letter, and she said she was going to use it as toilet paper, and for the attorneys and Schofield to KMA, or kiss her ass. So that was definitely interesting. But after that, she did a short redirect, and it was pretty much just trying to damage control what she kind of admitted in cross. It was mainly saying like, well, why did you wait 2-3 years before you submitted requests? It was mainly trying to defend on why she did not request certain court records or more before 2025. Because mind you, a lot of this stuff that she requested was in 2025. It was after Koberger had been sentenced or right before, and they kept saying like, well, if you knew that the professor did all of this, then why did you wait so long to request all these records? Why did you wait until after our second cease and desist letter to send in a tip to the FBI? And so on and so forth. And she was trying to kind of backpedal and say like, well, the documents were sealed and this and that. And it's like, okay, well, could have asked the defense attorneys. Why didn't you ask the defense attorneys? Or say, hey, I'm in the middle of a lawsuit. Or why did Koberger's defense attorneys not pursue this or contact you about pursuing this side avenue if you truly believed that the professor was this killer that you constantly accused her of. She didn't really have an answer other than, well, they were sealed. Well, they were this. Well, they were that. Okay. She also specified that the 114 videos were only about 30 minutes. But mind you, this is 13 videos or 114 videos over a span of maybe a month. Whether it's 30 minutes or not, the fact that TikTok's spread a little bit easier is still wild. I did want to add this in because I kind of forgot about it until I was rereading some of the notes. And what was so funny to me was that the lawyer was asking the TikToker questions and saying like 8 months, 3 years, and all this stuff. And at one point, she goes, "That's like 7 or 8 months, right?" "Yeah, 8 months." And she goes, "You're right. I'm sorry. That's why you have the business degree and I'm just a lawyer." And like so quickly moved on from it. It makes me laugh because the TikToker was constantly trying to get up one on somebody. If they messed up on like a number or like, "Oh, it's 115. No, it's not. It's 114. Oh, I'm sorry." She would almost get this like smirk of satisfaction. So it was very, very interesting to hear that comment come out of Ms. Olson because in my brain I was like, "Ooh, that's a snarky comment." But the way it was handled was just so interesting, I guess is the right term. And then we go into closing arguments. So the main point for the professors or the professor's lawyers' closing arguments was that the TikToker did accuse the professor of orchestrating a quadruple murder and having a relationship with a student. These statements were made repeatedly without evidence over a period of 3+ years, and these accusations caused severe emotional distress, PTSD, damage to the professor's reputation, and fear for personal safety. Ms. Olson is the one that did the closing arguments, and I think she handled it beautifully because when she was talking about damages, she made it very easy for someone who doesn't understand what compensatory or punitive damages are. And she also was so human when asking them. And it's weird to say, but she was. She goes, "Listen," and she did a full breakdown of all the costs over the few years that she's done. And then she goes, "We're only asking for compensatory damages of 1 million, but we're letting you decide on the punitive damages to punish her." And whether you think punitive damages are necessary or not, I do find it very intriguing how they did that because it gives the jury a lot of power. But it also is like, hey, we don't know. What do you think that she deserves to be punished, or whatever. It was a very interesting closing arguments. That's why I wish so much I had the transcript. But like I said, if you're interested, I will definitely go and grab them once they're open. But I did want to quickly go over what they said for like medical expenses, right? So they really were just like, "Hey, it's $4,500 for this little chunk, and then we're asking for the rest of it." And she showed some exhibits too. It was really interesting. I will say though that this lawyer clocked the TikToker pretty hard, and she said, "I already know what the TikToker will say." And she laid it out. I was saying like, "Well, it was only 30 minutes of video, and I didn't actually harm her career, and I didn't do this, and I didn't do that." And sure enough, so when the TikToker decided to stand up for her closing arguments, the TikToker started off with something that really was interesting to start off a closing argument with. She told the jury that people do things we don't like all the time, and that doesn't mean that they deserve damages for an opinion they don't like. Very bold to start off a closing argument that way, but she later then in her arguments state that the TikToker's videos totaled only 30 minutes of content over 3 years, that the professor's career was not harmed, that the TikToker's statements were tarot readings and not facts, that she honestly believed that she was helping solve the murders. The TikToker claimed that Schofield's distress was not caused by her videos. And then she requested that the jury award $1 in nominal damages. Now, you might be asking, "Spooky, what is nominal damages?" Well, thank God I pulled up the definition because I didn't even know. The definition is nominal damages are a small symbolic monetary award granted by a court to a plaintiff who has proven that their legal rights were violated, but who have suffered no actual measurable harm or substantial financial loss. These awards typically consist of a token sum, most commonly $1, though some jurisdictions or specific cases may allow slightly higher amounts, such as 100. But for this specific court case, it was $1. So, with their final instructions, they were let go, and they finally began deliberations around 12:47-48. And we waited for about 2 hours. And I was not shocked by how fast the verdict came back. I was shocked what happened with the verdict. So the jury returned the verdict around 2:48. The damages were broken down like this. The false claim of romantic relationship was $1 million in compensatory and $2.5 million in punitive. The false claim of orchestrating the murders was $1.5 million in compensatory and $5 million in punitive, which was the total award of $10 million. Now, really quickly, what are compensatory and punitive? Compensatory are actual damages, loss of income, medical expenses, and more. Punitive are punishment judgments or punishment damages, i.e. saying to the person who was doing the defamatory content, saying, hey, we saw what you did, you fucked up, now you have to pay this amount of money, and to show others around them that if you continue to defame, then you will get X, Y, and Z. $7.5 million in punitive alone and about $2.5 in compensatory. And unfortunately, we're not done. As much as I wish I could say that everything was finished, everything was great, and we're finally moving on, we're really not. As many of you know, the TikToker has continued to talk about it, saying that one of the jurors was biased, saying that there were multiple infractions and everything in between, unfortunately. Do I think that this will ever fully settle? No. Do I think that the professor will get her money? I would hope, but I don't know fully. And for those who are saying that they can garnish her VA disability, that is a heavily protected thing. So unless they garnish the actual bank account that the VA disability goes into, or if they go to the VA and show and the VA agrees, that is only how they're going to garnish it. They can garnish her actual job, they can garnish everything around her, but the VA disability in itself is heavily protected. I think some of the only few times I've heard of garnishments happening on VA disabilities are for alimony or child support, and that's about it. I haven't really seen any other garnishment of it. They might try, but I don't know. It is a heavily protected thing. So, will we see her back in court? I don't know. She has said that she wants to sue a few other people, a few other YouTubers that have talked about this. I don't know if she will try. I don't know. But it was a wild case. I am amazed by the total damage amount, and I'm just a little shocked that she has continued to talk about it. I get being upset with the judgment. I get upset with whatever going on, but at the end of the day, I don't know what to tell you. I do wish she had hired a lawyer. I would have been very intrigued to see how that would have handled or been handled differently, or if just in general how it would have gone, if they would have probably settled out of court or something of that nature. I would be very curious to see how that would go. But yeah, with all that being said, this thing isn't over. And I don't know if I will cover any of her videos. I really don't want to show her face or even say her name. But if it goes to trial again, then probably we'll be there to see it all over again. Because I'm just very curious to see what will happen, I guess is the right term of phrase. Because everything was unanimous. I even have it down here that it was like unanimous vote. They were even polled. Nothing changed. So it'll be very interesting to see. I hope the professor feels a little bit better and feels a little more vindicated. And yeah, I really hope this calms down. I don't think it will, but we'll see, right? We're always going to see. So with all that being said, thank you all so very much for being here. If you've made it to this chunk of the video, leave me a crystal ball emoji because it's been a long haul and you and me both are feeling it, I know. Or let me know down below what you thought of this case. If you want to hear about the actual Idaho murders and some of the stuff that they had, since they are releasing documents, I would love to sit down and talk about it. If you want to learn about the Tamla Horsford murder, or alleged murder, because I don't even know if it's an actual murder or if they still consider it an accidental death, I'd be loving to talk about that as well. Let me know just down below. Thank you all so, so very much for being here. I appreciate you all, and I will see you all in the next one. Stay spooky, my friends.